Hey everyone, Harry here to talk about voting rights and the interplay between state and federal courts, a topic that is a lot less dry than it sounds when you hear the actual practical upshot. Anyone remember Moore versus Harper? It was argued just a couple months ago, and we expect a ruling in June. The question here was, would even this very, very conservative U.S. Supreme Court go so far as to recognize, this is all coming back now, right? The independent state legislature doctrine. All right, let me tell you how that case was set up and why now it is deeply affected by some shenanigans that went on over the last few days back in North Carolina, where the case comes from. 10 years ago, to start the story, the Supreme Court struck down North Carolina's gerrymandering as being a violation of equal protection, and they went back to the drawing board. And it was a state. We see these things. They are so, in fact, common in the United States, where Republicans have a minority of support, but have really managed to leverage it very well, especially with state legislatures. And that happened in North Carolina. They went back and said, all right, we're not talking about race anymore, just raw political power. And they took a state that's basically even up, maybe slight advantage to Republicans, and made a map that has 10 Republican districts and 3 Democratic districts. And you can imagine how you do this, right? It winds up looking like a crazy patchwork quilt, but not even a quilt or patchwork, because it's just these very intensely Democratic districts, 3 of them, and then they win for sure, but then 10 can go to Republicans. And in fact, something like that did happen. Okay, now back to the U.S. Supreme Court, which took on another racial gerrymandered case, and we're going to be talking about a few pretty outrageous decisions. In the Rucho versus Common Cause case, the U.S. Supreme Court held just a few years ago. Guess what? We can't second guess these, even when they're ridiculously partisan, as, say, North Carolina's map is here, because there's no judicially manageable standards. That's when there's no judicially manageable standards, because it's all pure politics, nothing the court can do. But of course, they'd been deciding cases with plenty of judicially manageable standards for decades. But now they announce we're out of the state gerrymander business. You could have a state that totally screws minorities there. The thing that the court is one of its sort of raison d'etre for being there, and they just say we can't do anything. All right, so after that, and when the Supreme Court said we're out of the business of looking at gerrymanders, the North Carolina map, back the 10-3 one, comes up for judgment, and Common Cause, a sort of good guy voting rights group, challenges it under the state constitution of North Carolina and achieves 2 rulings that strike down the map as being a violation of equal protection and also crazy gerrymandering. They're able to find judicially manageable standards. And it's at this point that the Republicans, who now have defeat wrested from the jaws of victory, because now their hyper-partisan map has been taken away, they bring a case, they appeal this to the U.S. Supreme Court. Wait a second, didn't the U.S. Supreme Court say we're out of this business? By and large, yes, but that's where they come up with the cockamamie independent state legislature doctrine, and they want to say the decision by the North Carolina State Supreme Court violates the federal constitution, because state courts aren't allowed to be in this business, at least insofar as they trump legislatures, state legislatures have to be the bosses here because of one little mention of them in the federal Constitution. It seems to many people a bridge too far, even for this Supreme Court. So it was up in the air how the court would go. Now, that's all background for what happened Friday. In the meantime, in the election, the 2022 election, the state courts went much more Republican, and now there is a 5-2 Republican majority in the state Supreme Court of North Carolina. Now, North Carolina hardly ever grants so-called petitions for rehearings, like, can we have another chance, pretty please? It's done it like twice in 100 years. Well, you can see what's coming. On Friday, they decided we're going to rehear these two cases where just last year we held for the challengers and struck down this map. And the 5-2 Republican majority just announces it's a decision to rehear. Everybody understands it as raw partisan politics, which is especially unsavory when you're talking about courts. In general, courts kind of wading into politics a little bit is always ungainly, but this, everybody understands. They just issued these orders with nothing having changed in the underlying facts and law. The only thing that changed was the composition of the personnel of the state Supreme Court. Now, to be sure, Republicans there have been chafing and saying that the decision striking it down by a narrow vote was itself judicial activism and politics, etc. So we're just righting the ship to how it should have been. And this is, once you start getting into judicial politics of this sort, it's sort of no way out. Okay, so the state Supreme Court, this is the one big news is one state. Now you see, just as in the U.S. Supreme Court, through quirks and brass knuckles politics, the system, which provides for presidential appointments and Senate confirmation, has tilted things way, way, way right in the U.S. Supreme Court. Same thing in the state Supreme Court with elections. And now there's a punchline that this leads up to. One of the two cases they asked for rehearing on, Moore versus Harper, the very case that Republicans then appealed and the Supreme Court accepted and has heard and is waiting to decide. So there's a very distinct possibility that that very case is voided so they can do a petition for rehearing and the state newly Republican Supreme Court can reverse ground and permit the Republicans more free reign. What happens in that event? It means that the case in the Supreme Court goes away because it's no longer the same fight or case or controversy. And in the words of the lawyers, it becomes moot. And because the court can only decide live controversies between the parties. Okay, so a fair bit of law there, but you can use it to show your prowess, understanding what's going on with basically raw political moves, but not in a state legislature, not in the House Republican caucus, but in the state Supreme Court of North Carolina and arguably the U.S. Supreme Court. So first, see if this, naked power grab and reversal takes hold and North Carolina just reverses itself based only on the new elections and the party affiliations of the court. Oh, one more quick thing. Used to be you didn't have your party affiliations when you ran for the bench in North Carolina, and the Republican legislature passed a law 4 or 5 years ago saying you've got to put down R or D to really inject all this into the whole stew of judicial decisions and elections. So we're looking first to see whether the North Carolina Supreme Court gives a big gift to the state Republicans there. And by the way, people estimate that maybe 3 or 4 seats went the Democrats' way because of the decision striking down the map. Remember, they made a 10-3 map, and this made it more like 8-5 or whatever. That, and then you'll understand if in a month or so you get the ruling from the U.S. Supreme Court that Moore versus Harper is off the books. They'll have to wait for another case to examine the cockamamie theory of the independent state legislature doctrine. So more to come, and a lot's happened that if you're not a fan of politics and courts, makes you, and I'm not, got to make you very, very uneasy. All right, we will follow it. I apologize for all the law, but no way around it to understand this very important issue on the cutting edge of voting rights in this country, which is on the cutting edge of, the whole power dynamic and the way that a minority of Republicans have managed to really leverage their numbers in the Electoral College and the like to bat above their weight or punch above their weight or whatever. All right, so pretty important, pretty legal. Hope it was pretty understandable. More to come, especially on whether or not the Moore versus Harper case goes away because it's moot. Until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.